Good morning. It is 10 a.m. here on the Saturday, July 17th, 2021. My name is Aaron Hunt, I'm a partner here at the law firm Stace Hammond, and I head up the immigration team here. As always, this is not legal advice. This is just our commentary on immigration here in New Zealand. If you're looking for legal advice, there is an email address in the description below. Get in contact with us. I was going to record this video last night. I actually did record it, but my microphone was not turned on. Let's just make sure it's turned on today. And yes, it is. Fantastic. Okay, this is in relation to yesterday's announcements. Yesterday morning we had the announcement of some major changes to do with work visas here in New Zealand. And yesterday evening, about 5 o'clock, we got the actual changes to the operational manual. Those of you who aren't regular watchers, the operational manual is the rule book for immigration here in New Zealand. Those are the rules that that Immigration New Zealand apply when they're looking at your applications. So what's actually written in the operational manual is extremely important. And in yesterday's video, and also in the live session I did at midday yesterday, I said a couple of times that it comes down to what the actual wording is going to be, because quite often it is that detail in there, those little changes here and there that can make a big difference into how far these changes would go that were announced yesterday. And we've been through the changes, and there is an error. We'll come to that last. But overall, the changes are actually pretty good for migrants who are looking for work visas. We'll start off with the labour market test. This, of course, is one of the major changes that we weren't really expecting to come through. Now, with these changes, they aren't available online yet for you to see. They will be available in the next few days. It'll be an Amendment Circular 2021-28. And this will actually appear as changes to the operational manual. Now, these come into effect from Monday, from 19th of July, which is also the date, of course, they raise the median wage requirements to $27. So we'll start first with the labour market test. This is under WK 1510. Now, if you hear me refer to some letters, then some numbers, that's a reference to the operational manual and how that the structure works. So WK is the the work visa section, then WK1 section, subsection, and then sort of paragraph. So WK 1510 covers the removal for a need to provide a labour market test if you are applying for an essential skills job for a job that you currently hold. Now, there was a lot of, yesterday wasn't so much certainty as to whether that was for those who hold an essential skills or work residence visa. For that one, was the requirement to have a visa that had the job title on there, or was it open also to open work visas, partnership work visas, post-study work visas? And we're happy to say it is actually open to all. If you have a work visa of any type, if you have a student visa that allows you to work at least 30 hours a week, which would be an unlimited allowance for a student visa, then you can apply for an essential skills visa for that job you currently hold, and the labour market test is removed, which is a fantastic thing. Now, on top of that, under WK 2.1e, there's no need to provide IRD statements, no need to provide an employment agreement. There's also no requirement for a skilled match report for those lower paying jobs. That requirement is gone if you're applying for a job you currently hold. Now, those requirements are also duplicated in WK 310, WK 315 1e, and WK 321d, basically where immigration is making it extra sure that every single time that they reference to these requirements, they have made a note. If you're holding a job, already holding the job is not required. So it applies to all job holders who are on a work visa or a student visa, as I said. Now, with most student visas, you cannot work more than 20 hours, so it won't apply to those people, but those who have the unconditional, further allowance for more than 20 hours, unlimited work rights can do this. It also applies to those who are in New Zealand on the critical purpose visitor visa, who are working under that visa, have a right to work under that visa. So if you come to New Zealand as another critical worker on that CPVV, this will allow you to apply for an essential skills work visa without the labour market test, without the skill match report, without ID statements, without the employment agreement being provided. So it should be a very, very simple application. The one downside there is that the systems are not yet set up for it. So if you apply come Monday for this application, you can't apply through the online system to get this sort of exemption. It must be on a paper-based application, which is kind of ridiculous, but it means that the systems aren't ready for the applications just yet. What they've said is that end of August, you'll be able to apply online for these. Prior to that, it needs to be an application made on paper. On-paper applications require documents to be certified originals rather than to scan. So there is a more cumbersomeness to it, but of course there is no need to provide the labour market test or anything else. So overall, definitely a massive bonus. The other thing here is that typically when you're doing a visa application, the rules when you apply are the rules that are applied to the application. In this case here, they have made a change under WK31F and WK1510E that allow these rules to apply to those who have applied prior to July 19th. So you've got an application already in place. These rules will apply or can apply to your application if you want them to, most typically you're going to. So to my poor client who provided a labour market test yesterday, just as they were being announced, we are sorry about that, but that test is no longer required. Well, it won't be in 2 days' time. Next thing is that the 12-month visa, so those, as you'll know, there's the two visa scales. You've got the 3-year visa for those being paid above the median wage or at the median wage, and the 1-year visa at those below the median wage. That was a 6-month visa until recently. The government made it 6 months during the lockdown to sort of help New Zealanders get these jobs. Of course, New Zealanders didn't want those jobs and weren't available for them. So back to a 1-year visa a couple of weeks ago, and now they've gone this to a 2-year visa, which is fantastic. This is under WK 4.1 and WK 3/2010. There is also there was a stand-down period. So if you're on these shorter visas, the idea is that you'd have 3 years allowance for these, what they call low-skilled, what's actually the lower-paid visas, and then 1 year outside the country. That has been deferred until 30th of June, so any application made prior to 30th of June 2022 is eligible for this 2-year visa. And similarly with labour market tests, any applications made prior to 19th of June, so 19th of July, so prior to Monday, can have this applied to them. So if you've applied for a 1-year visa in the past few weeks and it's still being processed, then come Monday, it can be a 2-year visa when it gets granted. Those of you who have a 1-year visa, you're not getting an extension to that visa. It's just for new applications. The final thing we wanted to cover here was medicals, x-rays and police certificates. There was a big change here, but also there's an error here. We see as being an error. I think it needs to be fixed. And it probably will be fixed at some point. So first we'll start with the medicals and x-rays. Now, of course, how it works is that typically you need to provide these with an application. If you provide them previously in they're less than 3 years old, they would generally still be okay, and proviso that they're within 3 years of the last provided, and you haven't been offshore into an unsafe place for more than 6 months. Under A425D6, it states that medicals and x-rays do not need to be provided for an essential skills application where by an applicant who has provided the certificate with a previous visa application. Now notice the word there, who have provided the certificate with a previous visa application. A55E3 has the same for police certificates where the requirement to provide those is not required when they have been provided with a previous application. Now the word here is the issue. That's where I think the error lies. I actually got in law school, one of my first exams, one of my first assignments was a criminal law paper, and I argued versus the in the legislation where the word had been used by Parliament in the Crimes Act, and on that basis I said that someone was guilty of murder because of that distinction with versus the. The issue here is that if they had said the previous visa application, they would have meant with the most recent application prior to this one they're currently doing. When it says a visa application, it means any visa application ever previously made. Now, in regards to medical and x-rays, where they're required sort of every 3 years, you could provide it with a visa. You could for a visa application get a 3-year visa. After 2.5 years, apply for another 3-year visa. and again towards the end of that visa, applying for this, it's been 5.5, almost 6 years since your last medical x-ray, but this is going to allow you to apply again without it because you have provided it with a previous application. It also removes the whole question of have you been offshore in an area which has high tuberculosis rates, and that's the whole issue. They have this 6-month requirement for x-rays is tuberculosis. This sort of gets that out of the way. So I think the use of the word there is really problematic, because if it was the previous application, okay, we can sort of let that go to some degree. But means any point at any time previously. Same with police certificates. While I understand it's much easier to apply without having to provide a new police certificate, having there just means that at some point previously, it could have been sort of 3 or 4 years ago you provided one, but that was some time ago. So we can see immigration at some future point fixing this and putting the word the rather than as we don't think that was the intention when this was drafted. However, that is a minor issue, and for most of you is actually going to be a good thing. For you, just a bad thing for immigration, and I think the Minister has made a small error there. Otherwise, as it goes, this is great news for all those migrants who are in New Zealand looking to apply for a new work visa in the next year. This is going to make it much, much simpler, get you either a 2 or a 3 year work visa to remain in your current job. Again, this is for those in the job you're currently working in. If you change to a new job, it will still require labour market tests and all those sorts of things, unless there's some other reason they're not required. This is only for those staying in a job to help you maintain your employment and help the employer maintain your employment. So that is it for today. I hope you have a good day. Until then, ka kite anō, stay safe, kia kaha, and all the best.